merely changing man and woman into persons will make many provisions not reconcilable at all. For the time being, take it from me that Hindu Marriage Act will apply. I'll show how it applies, even to Special Marriage Act.
Section 3 of the marriage.
Correct.
80% of marriages in the villages, they're not registered at all.
To wife. So who will be the wife? In a man-man marriage, in a woman-woman marriage, or in a man transgender or woman transgender marriage, or two transgender marrying, who will be the wife? The answer.
And none of us are looking at
regulate social relationship.
the current scenario, Mr. Mehta, or also in the future. The
But the,
given is
the arguments, the way they are read for marriage,
yes.
and I'm saying this with a sense of responsibility, can be made, whether accepted or not is one thing,
we need to,
for challenging incest prohibition as well.
Mr. Mehta, we don't have to labor the point that the state can regulate even social relationships. Once a relationship between a parent and a child, can the parent say, I have absolute control over my child? No, the state says you have to send your child to school.
I leave it at that.
There's an obligation to make sure that your child goes to primary school. That's a relationship between a parent and a child, but we are all subject to the fact that you have to send your children to school. You have to get your children vaccinated. So these are obviously there.
Now coming back to that, your lordships would be required to rewrite. Coming back to the main
thing. Let's go and
see, my lord. Full blood, definition of full blood and half blood. Your lordships have read, my lord, as hypothetically as requested by them, man, woman, different categories of prohibitions, but your lordship said both prohibitions would apply, and your lordships would bear in mind the petitioners do not represent everyone who is in this particular class. Somebody may say that, no, I don't agree. Why should it apply to both of us? So it would be a risky thing to do. But are said to be related to each other by full blood when they are descended from a common ancestor, that is male, because the next word is by the same wife, and by half blood when they are descended from a common ancestor but by different wives. We can never reconcile this provision because it says biologically one man has given birth to a child through a biological woman. That's what they say. Number two, Lord, marriage between lesbians. This provision will be redundant because she can't have, Lord, full blood. Even if, Lord, there is a child from artificial insemination, it would not be a full blood child. So merely changing man and woman into persons will make many provisions not reconcilable at all. And, my lord, this full blood, etc., will have an inevitable impact on the succession. I'll show. Yeah, my lord, your ladyship's mic is not working.
Actually, then you also see the Hindu Marriage Act, which section 3G.
Yes. And your lordships may for the time being take it from me that Hindu Marriage Act will apply. I'll show how it applies, even to Special Marriage Act.
Section 3G.
3G.
Continued.
Yes.
So for instance, mama, some communities are mama,
niece,
mama and
even cousins,
sister's daughter.
Sister's daughter.
Mama's Banji and son can get married. Not possibly, but I inquired.
That is still protected because the custom
and the custom, the origin, nothing to do with this matter. The origin of the custom was that earlier the daughter-in-law used to be troubled in the household of the husband. So if mama is the father-in-law or fufi is the mother-in-law, then she would be like a child only. So that was the reason why, my lord, this custom.
There were many sociological.
There are sociological good reasons, my lord.
Land is another issue.
Land.
Mostly land is the issue.
Keeping the property.
Yeah, land is other issue.
Solicitor, 21A lifts the prohibition or the disability which is created by 19 only where a person who is a Hindu, Buddhist,
marries a Hindu.
Sikh, marries a Hindu.
Yes.
So if you marry outside your own religion,
You're cut out.
you're still cut off from the system.
19. Then 19 applies. Suppose I marry a Muslim, just giving my example.
Yes, you're right.
Then 19 would
You're
govern.
right.
21A would not.
There's one more thing, apropos your submission, to stretch it to a further extent, that 19 provides for severance only in respect of your family status, of the marriage solemnized under this act of any member of an undivided family who possesses these four religions.
So I lose co-parcenary rights.
Right. But there's one very important thing. So you lose your co-parcenary rights. In respect of all other aspects, you are still governed by your personal law.
My personal law. Yes.
So despite 19 having said you lose your severance, there'll be a severance from the status of a family, 19 still holds intact the applicability of all other aspects of your personal law.
Correct, my lord. I'm obliged, my lord. That's the submission, my lord. Therefore, my lord, I have been respectfully urging that it may not be a choice while examining Special Marriage Act not to touch personal laws.
It's intricately interwoven with.
It is
The
interwoven.
moment you get into 21A even, or even 19, succession is governed by the Hindu law, whatever it is. If it is Hindu law.
My lord, the deterrence was,
Yeah, that is meant for registration.
Lord, there were many marriages in those days when this 21A came, which were solemnized.
You can inquire from across the people in the court, how many have marriages.
My learned senior says his marriage is not registered.
Same here.
Where is the proof, Mr. Dwivedi? Where is the proof?
He'll raise our hands.
No, we
I'm eligible for remarriage.
If I'm not wrong, I think this compulsory requirement of registration of marriage was introduced a few years back when they said
Recently.
even if you are married according to Hindu law or any other thing, you must register your marriage.
Lord, earlier what used to happen, the marriage would be, my lord, solemnized as per Hindu rites, Saptapadi, etc., not under Special Marriage Act. But I want a certificate of marriage. So, therefore, my lord, it became a deterrent. That if I take certificate, I'll not be governed by Hindu Succession Act.
Of the marriage.
Correct.
80% of marriages in the villages, they're not registered at all.
Absolutely, you're right.
Tamil Nadu, I think, made it compulsory.
It is socially.
If I'm not wrong, Mr. Datar, I think
Relatives collect. and then
Absolutely.
it's known.
Ordinarily.
Tamil
Mr.
Nadu, it became compulsory
But
because
then-
of that form, no, self-respect marriages. Swayamvadayam. So that was made, I think,
Right.
section 7A or something was enacted.
Otherwise, you have to take evidence of, show your wedding photograph, album.
And if you require a visa,
Certificate from the Pandit.
require a marriage certificate.
Only for visa, it was-
Visa, another thing.
Marriages could be solved.
Lord, therefore, section 15 came. Now, my lord, the answer to this was by the other side that let both have both the grounds for divorce. Lord, as I recollect correctly, Lord, when this was pointed out that there are separate grounds available to both, and 1A applies only to wife. So, who will be the wife in a man-man marriage, in a woman-woman marriage, or in a man transgender or woman transgender marriage, or two transgender marrying? Who will be the wife? The answer was that they would both have both the grounds. Now, my lord, there is a problem. And the problem is, can your lordships read a statute which gives one additional ground of divorce to one class to the detriment of heterosexuals for which the Special Marriage Act is enacted? My lord, in case of a gay marriage, who will be the wife? In case of a lesbian's marriage, who will be the wife? In case of a transgender marriage, who will be the wife? These questions will arise. And my lord, we cannot leave it just that in individual cases, they would be taken care of. Across the country, this would arise. Then, my lord, right of a non-LGBTQ wife will be taken away because then husband can also claim alimony from her.
Just come again.
My lord,
But that's happening in heterosexual marriages too, Mr. Mehta. That's we've all come across it at different times in our jurisdictions where the husband also claims
But here only wife is given right. Please read it again. From the husband. Lord, may I slightly rephrase this? It says, if the wife establishes that she has no means of income,
Right.
she can apply, and husband is under an obligation to give her maintenance pendent litig. Now, my lord, first of all, there cannot be any decision by the court who is the wife in same-sex relationship. I'm not elaborating, my lord. But if your lordships were to read person instead of husband and wife, correct? So one person will be entitled to claim maintenance from another person, meaning thereby, in case of heterosexual marriages, to which this act applies. In fact, it applies only to them, according to us. A husband can also claim maintenance pendent lite from wife.
And
Heterosexual.
alternately, if it is interpreted to read as person only in the case of a same-sex marriage, then there will be a distinction between same-sex and heterosexual couples.
That again.
Because in the case of a heterosexual couple, the husband cannot claim maintenance under 36. But in the case of a same-sex couple, we would be reading it in such a way that either spouse can claim it from both.
But one of the men can. If he claims that I am the wife,
Oh, it depends. Yeah.
he says I am the wife, or in a lesbian couple, one of them says that I am the wife.
Depending
Because
on
one